Katz, a supervising deputy attorney general, and to Arsenio Mataka, who is a special assistant to the Attorney General here at the Department of Justice. Thanks to the entire team. Tatiana will be available also for any questions if you decide to go and dive deeply into the issue at hand today. So why don't we go ahead and begin? I will turn it over to Brian after I finish my remarks. Doug, after I finish my remarks. So let me go ahead and launch and get into it. We're here today to talk about California's precious waterways. We're here to talk about another thing, but principally we're here to talk about California's precious waterways. From the pristine Pacific coast in the San Francisco Bay Area to Lake Tahoe to California's waterways throughout the state. They are unsurpassed. But while we know the critical importance of these waterways for drinking water, recreation, wildlife, habitat, and also agriculture, there's something else. The Trump administration wants to clear the deck for fossil fuel infrastructure that would pollute these waters and damage our environment. Today, along with General Bob Ferguson of Washington State, Letitia James of New York State, I am leading a multi-state coalition and filing a lawsuit challenging the Trump administration's attempt to unlawfully curtail our state's congressionally authorized role to protect our waters. In Section 401 of the Clean Water Act, Congress authorized states to independently review the water quality impacts of federally permitted projects that result in a discharge and that require a federal license or permit to ensure that those projects do not violate state laws. In fact, Congress explicitly granted states authority to condition certification of these projects on compliance with our state water quality standards and, quote, any other appropriate requirement of state law, end quote. Crucial provision that I guess the Trump administration neglected. In doing so, Congress recognized the critical role states play in protecting and enhancing water within our respective borders. Our states' rights under Section 4 of the Clean Water Act are ingrained and have been recognized so far and so long as some 30 years by the EPA itself, by numerous administrations from both parties over the years, and both the Supreme Court and Circuit Courts of Appeal. But last month, in its haste to promote the infrastructure under the President's executive order, the EPA arbitrarily rewrote existing law dealing with water quality certification regulations. Those changes severely limit states' ability to review federally permitted projects under the Clean Water Act. These types of federally permitted projects subject the state's review, that are subject to the state's review, often include natural gas and oil pipelines, commercial land development, housing, hydro power plants, wastewater treatment plants, wetland developments, and other types of industrial projects. As you might imagine, these projects bring with them many environmental challenges. One of the only ways to ensure that these projects comply with state law is through the state's authority under Section 401 of the Clean Water Act. The EPA's new rule limits the scope of what states can review and requires states to take action within a limited time frame with minimal information. So let's be clear. This Trump administration rule is not about water quality. This is about pushing forward fossil fuel energy infrastructure. In our lawsuit, we argue that the EPA's drastic state authority under Section 401 is unlawful because it's contrary to the plain language, structure, purpose, and legislative history of the Clean Water Act. Two, it's contrary to binding Supreme Court precedent interpreting Section 401, and it's contrary to the EPA's own guidance on Section 401, which spans decades and multiple administrations. In order to protect the quality of our waters within our borders, we are suing the EPA today, requesting the new rule be vacated, relates to the Administrative Procedure Act and the Clean Water Act. We want to keep California's environment the envy of the world and the pride of every Californian. That's why we will be taking the Trump administration to court once again. And when I say once again, I have to make that just in these last 2 days of this week, we've already had to sue the Trump administration 4 times. And in the past 2 weeks, 6 times. It's not outrageous to say that this has become the modus operandi of this administration. Forget about the rule of law, do what they can to change rules, especially in these last 6 months of this president's administration, to try to undo and dismantle so many of the protections that you and I count on. And so we're ready. We'll stand up wherever we can. So far this week, Monday and Tuesday, we've had to take action 4 times against this administration in court. But then again, if you realize something, the president is acting like that Ponzi scheme operator. He doesn't mind gambling, and if he loses, he doesn't worry because he's not gambling with his own money. In this case, the president is gambling with taxpayer money in trying to change the law unlawfully. And if he loses, he doesn't care. It's not skin out of his pocket or money out of his pocket. And so we see what we're faced with. And people don't understand why we've had to sue in 2 days, 4 times this administration, 6 times in the last 2 weeks, 23 times since the beginning of 2020, and some 90 times since this president took office. He may think it's okay to try to be above the law. We're going to check that, not on our watch. With that, let me turn it over to Doug so he can say some words. Doug?
Thank you, Mr. Attorney General. It's really an honor to be here, and I completely agree that today's lawsuit really is necessary to protect Californians and to protect our environment and to restore the balance between the federal government on the one hand and the states and tribes on the other in how we implement the Clean Water Act and protect our rivers, wetlands, and our environment. You know, the Trump administration's final regulation eviscerates the authority of the states and tribes to impose important conditions on these kind of federal permits. In addition to putting these unreasonable and unlawful limits on the types of conditions that can impose, as the Attorney General mentioned, it really curtails the process for certification, trying to really eliminate the ability of the public to have a say and to limit the ability of states and tribes to be able to get the information they need to impose appropriate conditions. You know, there's a wide range of projects that are subject to Section 401. Anything from development projects, pipelines, things that are regulated by the Federal Energy Regulatory Commission, as well as permits under the Clean Water Act under Section 404. And in California, we see hundreds of these certifications each year. Most of them are routine, but some of them are critically important and controversial. And it's really essential that the state has the ability to impose these conditions. And I want to drill down a little bit. You know, I think in California, one of the biggest impacts is going to be with respect to hydroelectric projects. You know, under existing law, Section 401 of the Clean Water Act is really the only way that the state of California can impose conditions on these 50-year licenses for hydroelectric projects, like the proposed license on the Tuolumne River for the new Don Pedro project. You know, the existing license expired several years ago. It has totally inadequate stream flows below the dam, which means that right now, 80 to 90% of the water in that river is diverted. The State Water Board has adopted new protections for the river, but under the Trump administration's 401 regulation, the Tuolumne River would be effectively exempt from the state's regulations. And that means that the state couldn't protect the thousands of fishing jobs that depend on a healthy river, all the recreation and quality of life on the river, and everyone who depends on it. And it effectively overturns 2 Supreme Court decisions that gave the states this authority. I completely agree that the Trump administration's final regulation is unlawful and must be overturned. And I'm proud that the Attorney General is once again standing up for the people of California and standing up to the Trump administration's brazenly unlawful assault to weaken California's ability to protect wetlands and rivers under the Clean Water Act. And again, thank you for your leadership. And you know, this is important not just in California, but across the nation, but it's also really critically important in California.
Doug, thank you. And I think now we're ready to take some questions.
For those of you that would like to ask questions, you may do so by clicking on the raise hand icon to the right of your screen. Once approved, you will click continue. So you will be clicking twice. Once on the raise hand icon and then again to click continue to get into the queue. You can also email us questions or go through the chat in the app to ask questions, and we can read your question out loud. Again, to ask a question, hit the raise hand icon to the right of your screen. Once approved, you will click continue to be put into the queue. Our first question comes from Dustin Gardner. Dustin, you're now unmuted.
Thank you. I was curious, you mentioned the Tuolumne River Dam project. Can you give it more details of what sorts of regulations the state wouldn't be able to move forward with there?
Let me, and Doug, I'll let you chime in as well. Think of the action that the feds are taking this way. The feds want us to limit our review under Section 401. They want us to limit the scope of what we look at. They want us to look only at the point where the pollution enters the water. And so what they're asking us to do is look at the pipe and see what happens there without taking into account everything that happens beyond, whether it's runoff or whether the runoff of the pollution hits a wetland and becomes part of the fill, whether it goes into a stream, whether that pollution might create a reduction in flow in a stream as a result. All those things, they're saying, no, limit your scope to where the pollution hit water, essentially. At the same time, they're also saying, Justin, you got to do your review a lot faster, too. And so requiring us to do it within a shorter span of time means that we have less opportunity to collect the kind of information that lets us figure out if indeed this project will lead to devastation and harmful impacts to not just the water, but the environment and to human beings. And so by reducing the scope and time, they make it very difficult for states to fully protect their the rights that they have to protect the water that is in their boundaries. And so it can affect any number of projects, a hydroelectric project. It could affect anything that you can think of that would impact our water. And so you can imagine whether it's a dam or some other project, it's gonna make it very difficult for the state to fully enforce the law and protect the interests of the state. Doug, let me see if you want to add something to that.
That's really good. I think just to add on to that, the Supreme Court upheld in PUD number 1 more than 3 decades ago, I believe, that the states can impose minimum stream flows below these hydroelectric dams. That these large dams on the Tuolumne and other rivers effectively can prevent any water from flowing downstream in most years. And so part of what the state's role is to balance how much gets stored behind the dam and how much has to flow downstream so that we actually have a river. What the 401 rule would say is that the state can only regulate the discharge of a pollutant, i.e. how much oil or how much sediment flows downstream, but you couldn't say how much water actually has to flow downstream. And so it's really eviscerating the state's role as the manager of water rights within the state's boundaries. As the Attorney General said, this is much broader than just hydroelectric projects. So you have other federal permits like roadway development in the Los Padres National Forest 5 or 6 years ago. You've got levee improvements by the Army Corps. So this is affecting not just federal projects, but also private development. And it really is eviscerating the state's ability to put common sense protections that balance the interests of a project proponent, like a pipeline construction firm, with the interests of all Californians.
Go to the next question.
Okay, and just a reminder, if you can name your publication as well when you start speaking. The next person to ask a question is Amina. Amina, you're now unmuted.
Okay, thank you very much. I wanted to know how the EPA's rule sort of goes against binding Supreme Court precedent that you all talked about. Are you referring to the 1994 case, and could you just elaborate on how what EPA is doing is sort of goes against what the Supreme Court has said, and can EPA actually go against what the Supreme Court majority has said should be the case?
Well, the courts have recognized the right of states to know what's going on with the waters within their boundaries, and to be able to have some say with regard to projects that will affect their water and their natural resources. And so there are any number of cases that have addressed this, but it's not just the case law. It's also the fact that the EPA itself, for decades, has recognized the importance of Section 401 and the importance of states' ability to have a say in making sure that the water quality within their boundaries remains high. And so it's not just the courts, it is also the EPA itself. And I would say, by implication, of course, if it's the EPA for decades, that means you've had administrations, Republican and Democratic, who've recognized the role that states play under Section 401. Doug, please chime in.
Yeah, the only thing I add is that the two cases I was referring to are the SD Warren case, which I believe was 2011, and the PUD #1 case, both of which confirm the authority of the states under Section 401 to impose minimum stream flows and hold that it's 401 does not just encompass the discharge projects that discharge pollutants, but really does invoke a broader range of appropriate conditions of state law, as the Attorney General quoted from the statute. So what EPA is doing is really a brazen attempt to rewrite the law and overturn a carefully negotiated cooperative federalism approach and substitute their judgment to override the power of the states.
Next question. And if folks can give their affiliation, please.
Next question comes from Brad. Brad, you are now unmuted.
Okay, great, thanks. I'm Brad Hooker. I'm from AgriPulse, which is a California agricultural and environmental policy publication. My question is actually about the state legislature. I've been following this issue with them, and there was an omnibus trailer bill on public resources that was recently passed that allowed the state water board to somewhat circumvent this issue by skipping CEQA reviews ahead of time. It sounds like they actually found a workaround with this. Is there actually a need for litigation after that?
So, Brad, I'm not sure I know what you're specifically referring to. Let me see, Doug, if you have any thoughts on that. And then this is where I may turn to Tatiana to add in something.
Yeah, I can lead off, and Tatiana can chime in. The state legislature did approve a limited ability of the State Water Board to issue a certification where the applicant fails to comply with CEQA. We have a number of examples over the last decade where projects that need to get a 401 certification refuse to even start the CEQA process. And then suddenly they go to FERC and say, the State Water Board is preempted from has waived its right to certify because they haven't done it within this time period, even though the board is bound to comply with state law. And so what the legislature did was to take away that ability of project proponents to game the system, but it doesn't address the broader evisceration of the state's authority under this federal regulation. And it doesn't really address this ability, the types of conditions that can be imposed, nor the procedural problems of eliminating the ability of the states to require more information and to deem an application incomplete because they haven't given the state enough, or the tribe enough information on which to base their decision. And so it really is separate to, but is also a necessary component to the state being able to implement its authorities under the Clean Water Act.
Tatiana, if you wish to add anything, please do so, and just make sure you give folks your name and spell it.
Hi, everyone. This is Tatiana Gar with the Attorney General's office. I think Doug summarized it.
And actually your first name, so that people, you don't want your mom to read it in the paper the wrong way.
Oh, okay. Tatiana is my first name, and last name is Gaur. And Doug actually very accurately summarized the impact of the state legislation, because it really just affects one side of this problem, but it doesn't address the scope, which is drastically limited, the scope of review and decision that the state now is authorized to take under this new rule, and it doesn't deal with the other limitations that are imposed related to the ability to find a waiver under much more expanded situations, and also the focus on simply point source rather than all impacts from the project as a whole. So to answer the question, the legislation does not obviate the need for this litigation, and in fact, we still need to address the limitations on state authority. Thank you.
Thank you. Next question, Bethany.
We don't have any other questions at this time.
Well, we want to thank all those who participated. Doug, to you, Tatiana, also for chiming in. Thank you for the work that you have. Thank you for helping us protect California's natural resources, its water. Thanks for being so vigilant on this and working with the Department of Justice. We will collectively, and working with our state colleagues who are also filing in this multi-state action against the Trump administration, we intend to protect the water that our kids drink, the water that our families and businesses rely on, and we hope to be able to tell our grandchildren that we preserve this natural resource for them into the future. So thank you all for participating in this press conference today. Take care. Stay safe.